So we're moving on to the third and last part of this session pertaining to the justice sector and the settlement of tax disputes. With me are two distinguished colleagues, lawyers, Mr. Alex Karopoulos, partner in the Zepos Yannopoulos firm, and Mr. Panagiotis Pothos, partner in Kyriakides Georgopoulos law firm. Both gentlemen are involved in tax disputes for decades, actually, and today they are going to talk about the measures that have been taken during the last few years in order to improve justice. And more specifically, justice pertaining to tax issues. Dear colleagues, during the last 10 years, we had a multitude of laws under the pressure of the obligations stemming from the memoranda. We have many developments, for example, the developments in the substantial law and procedural law, and with regard to the tax disputes, we also had many changes aiming at accelerating justice. Everything started in 2011 with Law 3200. So I would like you to talk about these two laws and the developments that they brought about, starting with the tax procedure code. Alexis, after 6 years of the implementation of this law and of this code, how do you evaluate it? Thank you, Yannis. My personal view is that it is a positive evaluation that we can make. I have identified two main positive issues, two main positive points of this law. The first one is that it gathered all the scattered laws and which pertain to the different taxations and united them into one. Now the taxpayer can know better and far quicker what stands with regard to taxation. The second very important change in the tax procedure code is Article 9. Article 9 stipulated that when a taxpayer follows the circulars of administrative taxation, then he is not burdened by any tax or fines. This is very important because we know very well that in practice there are many tax auditors who are not abiding by the circulars. For example, in the last few years, we had the stamps for fixed assets. The circular was talking about one thing and the practitioners were doing another. So this tax procedure code has brought about very positive changes. Now, if we proceed to the issue of appeals, I have some mixed feelings. The objective of this reform was to simplify the process followed in courts. According to last data, ever since this process has been applied, only 40% of cases has ended up in court. So we can say that a lot of filtering has taken place. Moreover, we can also see that 25% are positive rulings, which of course is not a great percentage, but it is important to take it into account. The cases that can be considered as difficult or complex will not be handled by the General Directorate of Disputes. The General Directorate, however, can do other positive steps, like, for example, returning withheld taxes, giving back VAT, in the case of a bankruptcy. In other words, it's making very positive steps. But when it comes to the big and complex issues, the big and complex cases, it lets the court to decide. Panagiotis, what do you have to say? Yannis, first of all, thank you very much. I would also like to thank the Hellenic American Chamber of Commerce for making me the honor to invite me to this conference and allow me to talk about very interesting issues. Of course, I agree with Alexis. In other words, if someone wished to make an overall assessment, the result would be positive. However, there is always the but. In other words, there are issues that should have been treated differently. I believe that the triptych on which the tax procedure code was based was consolidation, simplification, and modernization on the basis of the international best practices. Undoubtedly, when it comes to consolidation, it has been very helpful. And I'm saying so because indeed there were some very fragmented provisions regarding the tax procedure. And it was very difficult both for the taxpayer and the lawyer and the court, the tax authorities to understand and implement. The only difficulty that I can mention is the terms and conditions that governed this code, terms and conditions that hadn't taken into consideration the concepts that had prevailed for so many decades. And this is why some problems were created. And even now, I believe that when it comes to terminology, there is an issue. We are not 100% familiar with the terminology, and this creates a huge problem now with regard to the appeal, to the administrative appeal. Obviously, the objective was to leave behind a system according to which there could be an out-of-court settlement, which basically was a settlement, a give and take, if you like, a negotiation. We were checking which were the damages, how much money was owed, and we were reaching a compromise. And we left that system behind and we moved to a system according to which there's going to be a court in the context of administration in order to have this checking of fact. So we needed more time in order to ensure this successful transition. A transition to a new system that is based on administrative appeal, that has specific rules, and that aims at filtering the cases before these arrive before the court, because this is the objective of the administrative appeal, as we all know. It's good to hear that you have a good evaluation of these changes. I want to say that I contributed to the shaping of the tax process code. I agree with what you said. I agree with what you said about the terminology and the different concepts. And I agree about the problems that they created. Yannis, I apologize for interrupting you, but I believe that this became even more evident with the so-called revoking statement, where there was a confession, for example, and one could revoke. And all of a sudden, many people reacted to what reactive means. Reactive, they said, and they raised some objections. Yes, this was a very successful step, a very successful institution, and should constitute a priority of ADE. Because indeed, the filtering, as you said, the assessment of the cases reaching the courts are very important issues and very innovative at the same time. Yes, Yannis, during the last quarter of 2021, 57% were positive rulings, which is a very important percentage, and we need to acknowledge, yes, of course. It's what you said, actually. Before, you mentioned about the two basic axes, which are acceleration of process and thus of justice. But I also believe, and maybe we can discuss about that later, We need to focus on qualitative justice or qualitative administrative appeal. And I believe that it is more than obvious that when it comes to big and difficult cases, and when there is anti-constitutional law, other parties need to get involved. Yes, when it comes to crucial issues, issues that have a materiality and importance both in numbers and in results, I believe that they have a phobic approach. Yes, maybe it would be too much to expect this authority to do everything perfectly. What it needs is the right staff that will be responsible to process even more complicated and complex cases, which, as you said, are more interesting to the wider public. Yes, because we're talking about full control. Let's talk about justice now, administrative justice, and everything that has happened during the last few years. Many changes have taken place. I would like to mention just two, which I believe are very important. The first one pertains to the tax disputes that can now be tried in first instance courts. And the second, the revocation of certain cases. So what can you say about these two? What can you say about these modifications of the case law? Look, 3,200 was a major step forward. In the beginning, I was rather skeptical about it. Because, and since we're talking in the context of this forum that is addressed to businesses which want acceleration, and we all know that the investors are interested in acceleration and in the taxation system, but also in the time that is required for justice to be given, we need to talk about these issues. We need to acknowledge their importance. We need to acknowledge that time is of essence. One thing is to need 3 years in order to process and resolve a case, and another thing is to need 20 years to do the same. So Law 3200 was an effort to accelerate justice by focusing on the customary and tax disputes by abolishing certain concepts that had prevailed for decades. And I'm talking about this revocation, as you mentioned. And by the way, I am jealous of colleagues who are doing these revocations in the Supreme Court, because they have a wide variety of revoking reasons, whereas we are finding it more hard to do the same in other levels of courts. And of course, with Law 4646 pertaining to tax disputes was an important law. So coming back to 3200, I believe that we need to revisit this law. Of course, justice needs to be accelerated, but at the same time, I believe that this shouldn't happen to the detriment of qualitative justice. And of course, there are other issues like the one you mentioned with the single instance of a jurisdiction, because, okay, maybe you have a very good judge, but for better or worse, tax issues and tax disputes constitute a combination of tax law, corporate law, and of an economic character at the same time, which I believe a judge in appeals court is not fully capable of processing. And this is also related to the education and training of judges, which is another very important issue. So if you have this single instance court responsible for resolving the issue, then how can you possibly take this case to the Council of the State if this is needed? I believe that this is something that needs to be revisited, because the only way that one can follow in order to take the case to the Council of the State is to diverge from the law. I agree with Panagiotis. Acceleration was indeed achieved to a great extent, because now in the Court of Appeals, approximately 6 months are required for a case to be processed. In 1 year time, a ruling will have been issued. But if the Court of Appeals doesn't comprehend the real case fully, then the taxpayer has no other possibility to take the case before the court and to be listened about real and important incidents and cases. And I believe that the Council of State and the revocation does not examine the arguments behind the ruling of the Court of Appeals. So there is an issue of interpretation of the law that is related to the revocation and to its acceptance. It is not clear exactly which reason for revocation is accepted or not. And the biggest problem is the complex tax issues that the court has to handle. Issues pertaining to permanent residences or transfer pricing, especially when it comes to transfer pricing, there needs to be a support by an economist. We have seen that repeatedly in the cases that we have handled. We need the support of an economist. And I don't know whether a proposal could be, for example, to have a legislative provision like the one pertaining to the return of a tax. Maybe something similar could happen for transfer pricing cases, in which there should be a contribution and support of experts. Yes, the latest figures show that the pending cases have reduced considerably. We talked about that with Mr. Bekramenos earlier on. However, we have reached a point where the procedural law has been limited, and maybe this is something that should be revisited. For example, maybe we should revisit the thousands of revocations on behalf of the public sector. Right now, if you have 3,500 cases in the secondary department pending, and you have 20 judges to rule over them, you understand that it is impossible for them to do that in 2 years' time, since we're talking about a huge volume of cases. So we need to follow a different approach and have a different organization, because for the time being, the courts are not in the position to handle all those cases. And many times, the first instance court is doing its best in order to meet the deadlines. But apart from that, there is also the Council of the State that needs to be examined and with regard to its performance. Now, I would like to ask you about the out-of-court settlement, which will be the responsibility of the newly established committee. What do you have to say about that? Allow me to say that it is a failed effort. Although it started as a fast-track procedure in order to resolve cases, and I'm talking about tax certificate, I'm talking about eliminations. So basically, it was a step in order to reduce the load that the courts had to handle by continuously extending the deadlines for rulings. Now, addressing to the committee of out-of-court settlement means that maybe you will need even more time than the one required if you had taken the case before the court. And The problem is that you may have spent so much time and no ruling is issued, which means that you need to take the case back to the court. So this committee was something promising in the beginning, but it proved to be failed. Just yesterday, I informed a client of mine that he would get an extension. He didn't quite understand, and he thought that this was good news. I explained to him that it was not the case. So we are trapped, basically, expecting the developments. Yes, Yannis, and this in combination with DED, where there are 9,000 pending cases in DED. There has been, of course, an extension given for the issuance of ruling. Now we have many silent rejections issued by DED. So again, what we can see is an overload of cases for which measures need to be taken. Yes, you are very right. And generally speaking, there is this feeling that the DED is understaffed. So, as I said earlier, maybe we should give priority to that, because it's a shame for an institution that has been so effective and has made so many efforts to not enjoy the trust of the taxpayers because it is understaffed. We don't have much time. We have 30 seconds. So if you like to add something, would you like to say anything about the case law, about laws in general? Last year, I had talked about the ruling of the Council of the State about the stamps. Last week, I was in the Council of the State and I talked about stamps on cash pooling, something that is of interest to many multinationals and groups. Again, we follow the rationale that it is out of field VAT, so it does not require a stamp. In 2022, we will have the ruling, so this is an important development and we will inform you when we know. As the President said earlier, an important decision that we will support will pertain to the complementary documents, complementary to the tax return, that is. I believe that this will be an interesting development, and generally speaking, this is what we have been talking about for so long, this constant battle against the legal issues and legal requirements. I believe that the developments that will come in the near future will simplify the process and will minimize the intensity of this battle. Yes, we're going to have some developments with regard to the revoking statement, so we will meet again in order to talk about it. I would like to thank my dear colleagues for being with us here today in the context of the tax forum, and I would also like to thank you, ladies and gentlemen, for being with us. Thank you very much.